project. This is largely principles based. We have been somewhat associated with making of this particular law, so we are aware that the hard work that has kind of gone behind making of this. This covers digital personal data only, so it does not cover data in the physical space. That would continue to be guided by general laws that are there in the country, like say in the Contract Act, you will have Indian Penal Code, Consumer Protection Act, things like those. So thankfully, no non-personal data is covered. In the previous versions of the bill, in fact, in the last one, when the Joint Parliamentary Committee gave its input, they were also very strongly talking about inclusion of non-personal data into the Personal Data Protection Bill. I have been personally against it because right from July-August 2017, when Justice Sri Krishna Committee was formulated, I've been very closely associated with that, traveled all across the country with him when physical consultations had taken place. And I'm aware that right from the beginning, there was never any thought process of adding non-personal data. So suddenly, towards the end, if you're trying to retrofit non-personal data related elements in the Personal Data Protection Bill, it can be catastrophic. That's number one. The other issues are there is hardly any precedent globally where such a personal and non-personal data coexist together in the same legislation. In the JPC recommendation for the previous bill, what was informed was one of the rationale that was put forth was that there cannot be two regulators and it will cause confusion that you have one regulator for personal data, another regulator for non-personal data. To that, what I had suggested is that you can have a single regulator. If your personal data protection related law is ready today, this particular regulator can regulate that piece. And in future, when you have proper consultation, etc., have another non-personal data related law, then the same regulator can be the regulator for non-personal data related law as well. We have some examples, some good examples in the country. For example, Reserve Bank of India. If you see the foreign exchange law related aspects as well as banking and finance sector, both the pillars are capably handled by Reserve Bank. So this is how, try to justify that, listen, it's not a good idea to quickly just put some elements of non-personal data into a personal data protection bill and say that now we have covered both aspects of personal and non-personal data. Third point about this bill is it is considered largely business friendly as compared to the previous versions. Of course, there are tweaks required, refinements required, both from a civil society perspective and also from a business perspective. A lot of, stakeholders have given their inputs. In fact, the extension has just come in. The last date was today, 17th of December. And that is why, like Ritu mentioned, that this particular session was curated around this date and time, because by now, mostly people would have given their inputs. Now, fortunately, what I understand is many of the important stakeholders have already given their inputs and closed it out, because no one wanted a last minute surprise that there would be no extension. Also, that upcoming holiday season, there was it was difficult that people would have managed to do additional work in the coming weeks, and therefore they have not taken a chance. Mostly the inputs have been provided. There's a lot of criticism also of this draft. One of them is that there is too much of delegated legislation. A lot has been left to rule making, etc. But when we spoke with the lawmakers, I think one of the draftsmen, so to say, what we have been informed is that this is by design, because in the digital law space, there is a lot which will evolve. So probably it's a good idea not to keep amending or altering the mother umbrella legislation. You can do all of that through rules. And one of the justification which has also been provided is that, listen, rules does not mean that the government has a free leeway. That also has to pass the muster of parliament. Okay, so that's how the government is probably trying to defend that why this structure is again a novel one, light touch one, a legislation which even a common man can read and understand, and why there is quite a bit left to rule making is because it is by design. We'll keep debating, discussing about it. I'm sure there'll be, points for and against, but, this I thought should be known to this group. The other thing is that, and this is for students to pick up really, some businesses and professions you will see get a fillip or a boost if this particular bill sees the light of the day the way it is curated, drafted right now. One is translation industry. If you see, this bill says that the notice and consent related document should be translated into all the languages of the as prescribed in the 8th schedule of the Constitution, which is 22 languages. Recently, there was an amendment to the internet intermediaries rules. Okay, it said a similar thing, that all your privacy policy, terms of use, you should give an option to the users to view those in any of the language of their choice as prescribed in the 8th schedule of the Constitution. Again, 22 languages. So when I personally spoke with the the minister, and I requested that can we consider this to be like a optionality? Can we bring this as an option, because for some of the businesses, translating into 22 languages could be quite onerous. But it seems like they really want this to happen because probably of the linguistic diversity of the country. There is a definite push towards it. So effectively what you could see is that a lot of new translation related business players could come into play, because this will be applicable to every single entity which is dealing with data. So therefore important one to take note of. Next is cyber security. If you have observed this entire trajectory, the way India's digital growth is taking place and technology related laws are taking shape, cyber security is being given extra importance for obvious reasons. Okay. During COVID times, when there was a lot of spurt in cybersecurity ransomware related issues, the CERT-in, Computer Emergency Response Team of India, swung into action. They came up with advisories which said that if there is any kind of data breach or data leak, immediately notify CERT-in. There should also be notification to users, data subjects or users. And that came as a surprise to all of us, because even the Information Technology Act does not talk about data subject reporting or, reporting, letting the individuals know. And we thought it's just a, probably advisory. So given the tough times, this has been written, and it is not mandatory. Interestingly, we have been assisting a lot of our clients in case of data breaches and data leaks. And the notices that come, typically they would say that we understand that such and such incident has happened. Question number 1, did you report this to CERT-in? Question number 2, did you report this to the affected users? And then they will copy paste very smartly the advisories link. So in a bad day, an organization cannot say, listen, you don't have the authority under IT Act. So you have to be then soft in your approach in how you are responding, unless you are planning to really challenge the authority, which is not a wise idea in a data breach situation, right? So you have to be smart about drafting, etc. So short point I'm trying to make is, and of course, thereafter, the directions also came in properly, which said within 6 hours of any kind of data breach, and you will have to report to the CERT-in within 6 hours. And there are other requirements like, your ICT system logs, okay, needs to be localized within India. It has to be kept in India for 180 days on a rolling basis. Your ICT system clocks needs to be synchronized with that of Indian time, etc., etc. So with this, and then look at the penalty related provisions that are there in the data protection bill, the highest ones, okay, 250 crore bucket and 200 crore bucket, these are all relating to security of the data and breach reporting related aspects. So you can clearly understand the vision and mission of the government that whilst we are looking at digital India, Atmanirbhar Bharat, a decade of India, all of that, but the insulating factor which they are really emphasizing very heavily on is cybersecurity also. So goes without saying that there will be a lot of investment further into the cybersecurity avenues in the country. Next is data protection officer or similar officer. So if you are a significant data fiduciary, now let me just bifurcate that how it happens. So internationally, you will have data controllers, right? We are using a different term called data fiduciary. And there is a very nice anecdote I love telling about this to my audience, that we asked Justice Sri Krishna that, sir, why would you like to name this differently? It's such a big problem that internationally everyone is calling it data controller. You are calling it data fiduciary. Internationally, everyone says data subject. You are calling them data principals. So he said that, listen, son, after the Britishers have gone, I would not like to call any of my fellow Indians as subjects. So therefore, let them be data principals, and the data controller should be data fiduciary, because I want a relationship of trust between them. So, it's a very deep thought, actually, if you look at it and just perceive it from that sense, because it is not simply borrowing concepts from outside and retrofitting it into the Indian context, but we have somewhat tried to do something new. And in fact, the new style of legislation making that you see is very novel. If this becomes a possibility, you could see not only other legislations in our country, but also future legislations of other countries can start aping what we are doing. Okay, light touch approach, common man can read and understand, etc., etc. So that's what has been the idea behind having data fiduciary. Now, the thought process also is that there'll be some data fiduciaries or controllers who will be crunching more data, more sensitive data, etc., etc. So they should have higher degree of responsibility or compliance requirements, and they have been categorized as significant data fiduciaries. Maybe we'll call them SDFs or for ease. So those SDFs have to do additional things like having a data protection officer. But others also, whoever is not a significant data fiduciary, need to have similar officers and grievance redressal mechanism, etc. So what probably you could see as a future avenue of business and new profession is data protection officers or similar people who are able to manage such a portfolio. You could have avenues created, and therefore maybe you can specialize in data privacy protection and become a data protection officer, or have a similar position, double hatting with other things. Probably, I don't know how it will shape up finally, but this definitely will be a good add-on to the professional ecosystem in the country. Next is consent managers. Now, a very interesting, novel, I would say rather novel concept in India. Now, what is a data consent manager? In very crude terms, let me try and explain this to you. Suppose I'm okay to give consent for ABC. Suppose I'm okay to share my mobile number, my email ID. You saw in one of the first slides, I have given my mobile number, my email ID, and maybe my organization's name. But I am not okay to share probably my health-related issues or my blood group or my bank account number, etc. So suppose I have a service provider, and I'm talking very, very crudely just to make you understand, okay? Suppose I give a power of attorney to a service provider saying that, listen, from tomorrow onwards, wherever I have to give consent, you please do it on my behalf, because I'm not going to read those pages and pages of notice and consent and whatever else is written. But I'm telling you upfront that I am okay with these three things to be given as a consent. And these items are a negative list. I don't want to give if there is a consent which is sought on these other data related requests. And you have this service provider which actually does it professionally for you. This is technically what the consent manager is. Okay. Now, there are concerns, of course, around this, because you are bringing in another third party into the system. Okay. So what data controllers are right now putting as a suggestion is that it could be an issue from a privacy perspective, because internationally there have been some frauds where there is a third party which has gotten involved for other laws. Okay. In fact, some of the large players, even if there is a ecosystem such as consent manager who ask for a particular information from the data controller or the company, say, which is crunching the data, the response is directly given to the data subject or data principal. It is not given to the data an entity such as a consent manager. So that's how they're trying to manage. These problems have been all informed to the government through this feedback process. But I mean, I have spoken personally, so I know that the lawmakers are very sort of gung-ho about consent manager as a concept. They really want to make this happen. And one of the reasons probably why they want to make this happen is that India has a lot of diversity, okay, and a lot of categories and kinds of people who are there. Many of them do not understand what they're consenting for. So what they're thinking is that probably if you have such a professional service being provided, maybe consent will be given in a more informed manner. So let's see how this plays out. Interesting times for India again. But again, you could see new breeds of these consent managers now being, cropping up, and people would be giving this probably as a professional service. Next, of course, is data auditors who would be required to be appointed if you are a significant data fiduciary. Legal work will also increase quite a bit, because now there is a specific way they have called out in which the notice should be drafted, the consent should be taken, how data controller to data controller agreement should be drafted, data controller to processor agreement should be curated, because there's a lot of onus, responsibility, right? When you look at that the penalty can go up to 500 crores, it suddenly becomes a board level discussion. And then people are ready to invest time, effort, and money and ask the, maybe the in-house lawyer or external lawyer to say, listen, look at the agreement very carefully, because in a bad day, that will be probably a savior to check that what was supposed to be done by the data processor as per the agreement, and what was beyond their remit, which they have done, and therefore the liability should be theirs and not of the data controller. So very interesting times from a legal perspective. A lot of drafting, aspects relating to the process laying out for data privacy protection, etc., would be handled by lawyers. Then you could also see solution providers in IT solution providers who are giving solutions in relation to consent procurement. Okay, now what this law says is that when you are giving out notice and when you're taking consent, you need to have keep evidence of that. So in a bad day, if suppose, once goes up and says, listen, I never gave you the consent. So you have to prove it as a data controller. So therefore, important aspect is that this all should be done in a manner that you are able to keep this as an evidence. There'll be other things like data protection impact assessment, etc., which, I'm sure you'll see these as new services being provided. So the next important point is the concept of deemed consent. I thought I'll spend little time on this because it's somehow people have taken it very negatively. It seems like it has got a bad connotation because probably people have not understood, or the nomenclature could have been a different nomenclature used. But trust me, only consent cannot be the only ground available for processing of personal data. Okay. There are other grounds of processing also. So just like consent is a ground, I take consent from you and therefore I will use your data maybe for payroll purposes, etc. There can be other grounds also. A typical example is in an employee investigation, if you read the Information Technology Act today, and also the in the sensitive personal data rules, if consent has not been taken earlier in some manner, in an employee investigation scenario, you will have to go in a bad day where maybe that employee is doing something wrong and has stored something in the laptop. You'll have to take consent saying that, listen, I understand that there could be sensitive personal data in the system. Please give me consent so that I can look into the laptop. Now, this becomes sometimes counterproductive, very tricky, and therefore you can understand why there is a requirement to have other grounds of processing. Let me also give you some weird ones so that you understand. Patient dying in a hospital, will you first say that, please write down, give me your consent, and then we start the procedure? So you can understand, right? There will be situations where you have to go beyond consent as a ground of processing in order to process the personal data of a person. Okay. So this other avenue, unfortunately, has been named as deemed consent. It could be named as other grounds of processing or whatever. It would have been better perhaps. But that Shumantra will go through in detail. But I thought I'll clear the air about it. Is nothing super negative. Internationally, it is very well known, and we are just trying to pick up some of them and have it in our law. One of the criticisms of this law is that there is no sunrise period which has been given, which is basically, when the law comes into effect, how much time will I get to prepare for it? Earlier versions of the bill, there were requests for 18 months and 24 months. When we had a sort of an oral discussion with the authorities, what was orally informed is that adequate time will be given, do not worry. But unfortunately, nothing is written in the law. So a lot of submissions which are going in right now, the request that is being made is please put in some timeline.